Divorce from Venom.
Okay, the final part of the day, we're going to talk about what I consider the remaining issues of family law, the important stuff that we talk about, that we go through, and you will have consults on, and you need to be able to have some familiarity as to each one of these issues. So finally, in our family law procedure, we're going to start with annulment. You will get a ton of requests every time for annulment. Have fun with them. I will just say this, that I've never seen a contested annulment work, but I see uncontested annulments work all the time. And a lot of times they're uncontested. So just know incest, underage marriage, bigamous marriages, lack of consent marriages are all kind of things that can happen. But primarily you're going to run into impotence. That's old people are going to get married and they're going to be mad that they can't have sex. As it turns out, one of the secrets I found of being a family lawyer is retirement homes are crazy sex homes where old people they're through their little inhibitions of whatever, and they are ready to roll. So be careful if you put grandma into the home. She may just be going into a crazy, wild, world of like junior high. It's not really a sugar daddy if you also are there. At least not as effective. I don't know. There's probably is like the 90-year-olds get like hit on the 70-year-olds, and it's like, oh, it's such an age difference. That's the kind of part of it. Patrick, you have anything to say there?
About old people having sex?
Yeah. I heard you say that. I'm like, man, I must have missed a legal point. I don't know. Mental illness is definitely one. And then there's the mistaken belief of pregnancy. That's where that one actually comes up, and it has something to do with the moon cycle or something like that. It's how many moons it takes before you find out. Bottom line is, if it's an annulment, it's got to be something really quick. And you tell them, say, look, I can file for an annulment if it fits one of these requirements. If the other side objects, the court's probably going to grant the annulment. Occasionally I'll get a mad parent or something like that says, I need this thing to be annulled. We try to come up with an argument, use that mistaken belief of pregnancy, and try to work it out from there. But those are tough ones.
Let's say you do have somebody who comes in with their parent and they're like, we need an annulment. They got married, like girls like 18 or whatever, but she never thought that she was pregnant. She was like, oh my gosh, I'm in love with this 25-year-old and this isn't weird at all. And she got pregnant, but did they, like, let's say for the sake of pregnancy, where mom did her research and was like, oh, she thought she was pregnant, that's why they got married. Does he have to know that they got married because of the pregnancy? Or is that something that you can be in court and be like, well, the real reason why she got married to you is because she thought she was pregnant?
Was he have to bring it in good faith?
Yeah.
Let's say,
I can't. I mean, I don't know. I don't know what the other person's knowledge is. I mean, I don't know if there's an issue there.
I know you've had one before.
I don't remember that particular part of it. I know that I've gotten, like, the dad is mad and it's sort of like a shotgun divorce, like we're going to get rid of this thing.
What's about property at that time? So then would they be, and then all it went through?
Yeah, then it's going to be like if they were never married.
Dang, that's complicated.
Yeah. If they had time to get property, though, probably it's not going to happen.
Yeah, is there a timeline? Like if somebody comes to us 6 months after marriage and claims that they had a mental illness, that they were incompetent at the time.
Yeah, incompetency is definitely one.
But does it have a timeline?
But if there's
did you become
Oh,
Like, is there a timeline between about getting an annulment.
I would just say the less amount of time it's happened, the better chance you've got, but I don't think there's gonna, I mean. I can't imagine that if somebody's been together for a year, that there's any chance that there's gonna be an annulment under even mental health,
Okay.
be my guess.
Annulment's fast.
I know, and we get them. I mean, that it's going, you will get a consult every year on
Yeah.
annulment.
Sorry, guys.
I've done an annulment on a voidable marriage, not a void. I think those annulment, some of those grounds are, void. But I had one where some women got married by someone that was a reverend.
The solemnization one.
Yeah, well, yeah. What do you call the church where anybody can be a reverend? I am in that group as well.
It
Whatever.
feels like if you're a priest, you should know.
I'm not a priest. I'm a reverend. I didn't pay the extra money to get the frame certificate. Otherwise, I would be able to tell you. But anyway, it's fun.
Okay. Well, Reverend, I mean, we'll just go on the assumption that voidable is possible. Let's just have like a rule. If there's a possibility of an annulment, let's throw it through the practice area group. I think just to get where y'all can sit as a board of directors and say, yeah, we won't, I like that trick. Oh, good.
That's a fun thing to do at a quarterly meeting.
I feel like that the fraud aspect of it, that we knew that we were going to get out of this thing later. Yeah. Okay. All right. The next one is heart bomb torts. In 2017, we all thought that this was going to be gone in North Carolina. And lo and behold, the Court of Appeals went the exact opposite way. The Supreme Court backed them up. So it is still constitutional in North Carolina to go after criminal conversation, alienation of affections. You will have those cases that will happen if you do have a alienation of affection kind of claim. It needs to happen prior to the date of separation, and it is a separate claim that go on, and some of these cases have been pretty valuable. So if you have a third party that is interfering in the relationship, it is still worthwhile to make at least a claim on it. And a lot of times you can get a little bit better settlement, even if you don't want to actually go forward in the alienation of affection actual claim. Divorce from bed and board is the next factor. Grounds. I see this claim a lot. It is not technically a way to kick somebody out of a house. I think that's what people want to have it happen. The case law is the burden of proof is on the plaintiff to show the defendant's conduct was not caused by the plaintiff's act. What must be proven, however, is not the negation of every possible justification for the defendant's conduct. The plaintiff must prove only that he or she did not engage in conduct that provoked or justified the defendant's conduct. And you can see where what claims are there for divorce from bed and board. The order itself just grants a divorce from bed and board. It does not grant you the property necessarily. I think some of the judges will take it like that and will try to get that to force that person to leave. But that does not necessarily award you the house or any of the other parts to that. Mm-hmm. Correct. I think interim distribution definitely would give you the house. And a lot of times the courts will just say, like, look, I'm going to in equity try to make this, kind of force that person to move or whatever that may be. you'll see it. I don't file many of these divorce from bed boards. Some jurisdictions file them a lot. I think Catawba County, it's like crazy. They file them all the time. It's like they're not filed in any other county, and then you go to Catawba and there are just a ton of. I think they use it to try to get people out of the house there. Be my guess. Yeah, I don't know. Do you guys see many at divorce from bed and boards? Yeah, I think it's only if you're in Catawba County, you need to study these things carefully because they love them. Okay, drafting orders. Again, you want to make sure that you are volunteering to draft them when you can. Smelts see in 2001 is a reminder of a ton of cases that say you should not make a finding of fact says that a plaintiff testified that the defendant was a poor parent. You need to make a finding of fact that the defendant is a poor parent. Does that make sense? You can't say what somebody testified to. That's not a finding of fact. You have to say that what happened happened. Okay, I know I'm skipping through these pretty quickly because this is a big one and an important one. Contempt. A show cause must be issued to the defendant that must be given notice, and the court should identify if it is civil and or criminal. Contempt. That's the Watkins case. So in general, what you want to do is you want to make a motion to find that person in contempt. And then you want for the court to issue a show cause as to why they are in contempt. Civil contempt is to coerce the defendant to comply with the court order, not to punish him. Defendant's failure to comply with the court order cannot be punished with contempt hearing unless the disobedience is willful. The Vaughn case in 2006, the court does not have the authority to impose civil contempt after the party has complied with the order, even if the party complies after being served with a show cause motion. That's criminal contempt, not civil. You can't compel somebody to do something they've already done. Jackson case, 2008, a custodian should not violate the visitation order, but if he or she does, then ordinary proper response is a finding of contempt, not modification. In other words, if mom doesn't send the child over, that's not necessarily a modification. You should hold them in contempt. It doesn't mean that it's in their best interest to change the order just because mom didn't send them over. Now mom's in contempt. That's why if the issue is whether or not somebody is sending a child over, you need to file a motion to modify and a motion for contempt. So the court can punish the person and modify the order. And so the judge has the option to do either or both.
What's my consent, but not. Show cause.
Yes. Because where you're not going to change the burden. Because the motion to show cause changes the burden over there. But if you were just saying like, look, I don't know what the situation is. I don't know if it's willful or not, but X is happening. You may not want to do it as a show cause. You just make a motion for contempt and notice it on and let the court decide. Because then the court might decide to say, okay, I'm going to do a show cause and be involved in it.
Was there a case this past year? I could be making this up, but I'm not sure. It says for criminal contempt, there has to be an issuance of a show cause.
Maybe because you have to give them the shot. I know that there was something about given that you got to be able to give them the rights of a criminal in a criminal case. I don't know. Let's see a minute.
But talk about full day CLE, you could do 3 days on contempt and then leave thinking you know it, and then could do it some more.
I think that you can serve the attorney, but you also have to serve them individually. Cause like in my case with Taz, they served both me and him because they didn't know if he had hired me if he's gonna hire me for the. So that makes sense. Well, I mean, like a courtesy call.
I don't know. North Carolina prosecutors say that verbal notice by a judge the defendant is charged with criminal contempt, and description of defendant's action may be contentious, satisfies the requirement. Summary notice sufficient and written order to appear and show cause not required for summary proceedings for direct contempt. Gosh, and because you have to also determine whether it's direct or indirect contempt. Most of the time, we're going to be talking about indirect contempt. Although, I mean, this is what you're talking about. I mean, you could really go down that one if it's indirect contempt. I still think the best thing to do is to do a show cause and have that order there. But most of the time, I don't even want the other side to go to jail. You know, that's not really what I'm seeking. I'm really seeking
I don't do.
attorney's fees.
Simmons,
Mhm.
other side, and it's really something else that we're working out.
I will note the Grissom case because I think it is important from 2018. Plaintiff must act purposely and deliberately or with knowledge and stubborn resistance to prevent defendant's visitation with a child. When evidences the plaintiff was prepared the child to go, encouraged him to visit, and told him he had to go, the child refused. The plaintiff did everything possible short of using physical force or threat of punishment to make the child go to his father. While perhaps the plaintiff could have used some method to physically force the child to visit father, even if she improperly did not force the visitation, her actions did not rise to willful contempt of the consent judgment.
That happens all the time. 13-year-old girl decides she doesn't want to go see dad anymore.
Just because these issues can be really tight, I copied Cheryl Howe's article from 2018 on civil contempt not always being the appropriate remedy. This is when, and it talks a little bit about all these issues about the requirement and encouraging a child. It's the detail of the Grissom case and kind of talks about compliance orders rather than civil contempt. So, as per usual, the school of government is going to be a guide stone for the court to kind of break down and give you what a contempt is going to look like. I don't see that she dealt with the show cause aspect of that though.
Well, I heard that come out of our courts in Buncombe.
Yeah, I mean, that certainly sounds. Well, I'd be open to kind of seeing what other things might be there. I can't really speak to that directly.
And it's also become kind of custom now too in any contempt proceeding. At the top of it, the judge will ask. If the judge doesn't ask, I ask. are you proceeding in criminal contempt or civil? And though you don't have to say that at the top necessarily, I think that's becoming more and more, at least in Buncombe, that's becoming more and more custom.
All right, okay, there's, several different things as far as what contempt is and where that's gonna go from. Compelling, a lot of times we get orders and the other side doesn't follow them, and it really is frustrating to a client that they've spent all this money to get an order and they cannot enforce it. So, staying tight with it with the client, doing as many show causes as you can. I mean, it's not been unusual for me to do 4 and 5 of them in a case. That you can see that cases on continuing wrong and some issues along that line. But I do believe we want to make sure our orders are enforced. All right, number 12, expert witnesses. I didn't put much in this one. So, I would really like for the family practice area group to put together a list of expert witnesses that we use in our cases. And we just, have some go-tos and try to get some benefit of the fact that we're a larger firm. Estates and family law, you may lose your status as a spouse if you have a divorce from bad board might be enough, but it also could be a spouse who voluntarily separates from another spouse and lives in adultery that has not been condoned. That may be reasons why you have lost your rights as a spouse under estates. You can see that there is abandonment, misconduct. These are all parts of surviving spouses not being eligible to take under an estate as a spouse. Okay, number 14 is attorney's fees, and I really have been pushing attorney's fees more and more. Each area of law in family law has a different kind of attorney's fees that goes along with that. In Walter v. Walter, you've got attorney's fees in contempt that has that's a 2021, the court vacated an award of attorney's fees in a contempt proceeding arising out of alleged violation of a custody order because the party awarded fees did not prevail in the contempt hearing. So prevailing party was required in in August of 21 case. You can look at the Blanchard case, which was in September of last year. The Court of Appeals found that when the trial court awards fees for contempt proceeding, it is immaterial whether the party was prevailing party, and they quote 50-13.6. So follow along the reasoning in Blanchard if you're wanting attorney's fees in a contempt case. Well, you can see that kind of follows through. Generally speaking, attorney's fees are available in child custody proceedings. You have to show a need for the attorney's fees in child custody. So if both parties can afford an attorney, then there's really no attorney's fees in a child custody case. Equidistribution, there is no provision for attorney's fees. You can only get it as a sanction for failing to provide something or whatever that may look like.
Judge Scott was telling me the other day that it is clear that in child custody cases, you are guaranteed attorney's fees on contempt motions. That's
what Blanchard is talks about here. Yeah.
That's even if you get in and the behavior has been corrected or anything like that, they still would be attorney's fees.
Alimony, you can get child attorney's fees based on need. as well. So that those are the areas of law that you want to put your time into. Because of this, a lot of firms that do family law only will separate their files. So the time that they do in a child custody is separate from the amount of time that they do in an equitable distribution. Since one of them you can get attorney's fees for, and another one you would not get attorney's fees for. So you try to divide that up as you go. We've never really done that, but our judges in the past have been fine to say, well, half of the case of the fees in this case are attributable to custody versus equitable distribution. I think it might be better if we start thinking about doing it separately. But I don't have any particular answer on that. Patrick, you have anything on attorney's fees that you want to add to that?
No, I mean, the court will look at making, an even playing field. That's kind of the policy, the public policy behind it. Inefficient means to defray the cost of the action, acting in good faith. But the court will say, did Sam have the same ability to hire counsel and meet, Virginia or whatever, in it. The only thing I'd say about attorney's fees is they do apply to intervenors as well. Intervenors can get them, and they can be awarded against them too. And attorney's fees, you don't have to, in custody actions, especially, custody action. I mean, you could win your case in custody. You could be primary, and you also could then owe the other side attorney's fees, because that's all it comes down to. Insufficient means to defray the cost of the action, acting in good faith, and then it's in the discretion of the court. That's it.
Yeah, it wasn't long ago in Buckham that I got attorney's fees for a 50B case. Where I said that the plaintiff was acting in bad faith, and we got attorney's fees in that matter. So, I always think if you're going for attorney's fees, you should do a very reasonable amount to lower it. It might not be our actual fee. Say, Your Honor, we're asking for $1,000 in attorney's fees in this matter, or something like that nature. Try to make it to where you put the pressure on, and the judge may very well award you attorney's fees. It's a symbolic victory for your client. And if it's too much, the judge may not give you any of it. All right, Lawyers Mutual, to wrap up this talk. And I specifically don't have 50Bs and DSS cases involved in this, and I think that we really do need to have separate ones, because I think 50Bs are such a big part of what we deal with in domestic cases now. And even though I think Department of Social Services cases are a little outside of what this spoke is for, it's a lot of what the family practice area group is going to be dealing with. So I think we need to really work about evaluating that. But I do have a list on what things go wrong. Lawyers Mutual did this as an article. And they found that there's almost as many family law malpractice cases as there are real estate, which is kind of crazy. The number one, and not really the only one that really comes up in family law, is allowing your client's potential claim for alimony or ED to lapse. A divorce happens and it's under your watch. And remember, you may not be a party to that divorce. The divorce might be filed separately and you don't even know that's going on. So if it's been more than a year and you haven't filed your action because you're negotiating it, you're dealing with separation agreement or something of that nature, you may want to just go ahead and file equitable distribution, because all you have to do is file a claim beforehand. But you have to do it even if the other party has filed a claim for equitable distribution or alimony. you need to always go back and you make your own filing for alimony and equity distribution if you think that applies. And make sure that you've served it so that service doesn't die. Do not rely on at the end of the divorce judgment saying that all claims for equity distribution and alimony remain available, because that is not enough. You have to actually make that claim. You can't just reserve a claim that doesn't exist. Does that make sense? So you want to make sure that you've got that covered. If this does happen, let us know. We can get Lawyers Mutual to give us review and help us go through that. And considering how much money that we spend on Lawyers Mutual every year, I could have a couple more of those Jeep Grand Wagoneers if we decided not to have insurance. But it's expensive, and that's, we do it for those purposes. But it's kind of crazy that family law is one of those areas that there is a lot of claims in, because in general, people, don't be scared of our actions. Custody cases, do your best. Get your result. Lawyers Mutual, it's not going to be an issue on that. So, what we're trying to do is do a good job for our clients. I don't want you to be scared of doing that. That is a ton of stuff to go over in a day. It is family law in a nutshell. If you went through family law class in law school, you would meet, maybe for an hour a week or so. It's usually a 2-hour kind of class. So basically, this is almost half of the time that you would have had in that family law class. And we're not going to bore you with a lot of stuff. It's going to be, this is how to do it. This is what to file next. So I think that we cut through, it feels like to me, a whole semester's worth of family law in a day to go through. But my goal is to try to get you that basic feeling where you feel pretty comfortable. This is how we handle cases. This is what we do in it. And obviously, when you come up with specific issues, we're going to be able to chat and go through that. So does anybody have any question about this or any part of family law that we want to go over? Maybe you feel like it's like me. It's like at 4:30 of the day, you're kind of like, oh my gosh, we spent a whole day just talking about it and not actually getting into any of our cases. All right. Well, this is I scheduled this. Let me end my recording because